Good afternoon, everybody. Welcome to today's lecture live on LinkedIn. My name is Ross Pitkoff. I am the founder and the owner of the Pitkoff Law Group, which is a New York City-based business litigation law firm. We help business owners resolve complex disputes between partners, shareholders, and third parties. And we also act as your family-first business-oriented law firm, providing guidance on preparing operating agreements, shareholder agreements, protecting your company, and putting items together such as vendor agreements, asset purchases and sales, etc. Today, we are going to be discussing a very interesting topic. It's a bit of an extension from our last live where we focused on injunctions. This one predominantly is going to be focused on stopping your business partner from either stealing from you, destroying your business, or harming you. So today, we actually are not going to use a slide deck. It's something that I think we'll go back to in the future. But the way we're going to do this is, number one, we're going to talk about the protective documents that you should have in place as you have your business with your business partners and what to look for or what to add into those documents. Then we're going to consider what you can do when a dispute arises. And when a dispute arises, we'll consider the ramifications of if you have an operating agreement or not. And then we'll discuss the out-of-court process as well as the court process to consider how you can actually go about protecting your interests. First off, if you have any questions, please feel free to just put them in the chat. I hope to be able to see them. I believe last time we had an issue with actually viewing them, but to the extent that we're able to view the messages, we will get back to you. Also, if you're, have other questions that you think might be a good topic for a future LinkedIn Live, please don't hesitate to put them in the chat as well, or send us a note or email so that way we can respond and consider to use it as the next topic for when we next meet again. Happy Friday to everybody, and let us begin. So first and foremost, when we set up a company with partners, there's all types of ways to go about them. And there are multiple different types of entities that you've probably heard of that you could utilize to create a business with partners. The most common types of structures that we tend to deal with are limited liability companies, LLCs, and those in New York are governed by the New York Limited Liability Company laws, which is a statute in New York. Then there's corporations. Corporations are governed by the Business Corporation Law, often referred to as the BCL. And then partnership agreements where there isn't a separate entity governing the relationship between the business owners, that is governed by the New York partnership laws. Anytime you are entering into a business agreement or relationship with partners, it is always highly recommended that you set up an entity, be it an LLC, be it a corporation, and then have operating documents that govern what goes on within the business. So we're going to be speaking, the phraseology shifts a little bit. When you're dealing with a limited liability company, we call that an operating agreement. When you're dealing with a corporation, it's a shareholders agreement, and then there are bylaws that govern the scope of the corporation. So for today's purposes, we're going to be speaking about an operating agreement, but just know that the same rationale and the same ideas generally apply to an operating agreement, a shareholder agreement with bylaws, etc. So often people go into business together and they say, you know what? I don't really want to deal with all the issues of having a long operating document. I just want to either do something really quickly or just get into business, verbally agree on some things and move forward. And that works so long as it works. In other words, if no issues come up, then there's really no problem, right? And that's the general basis of law. You don't need an attorney until you need one. You don't need an operating document until there's confusion or until there's a dispute. And then you're saying, hey, where's that document that tells me what it is I'm allowed to do, what I can't do, and what my partner can and can't do? Now, a couple of clarifications. Setting up an operating agreement doesn't guarantee that there won't be any litigation. It is not a guarantee that a dispute will never come up that needs to go to court. That's the unfortunate reality of being in business. But what it does do is it ensures that there's a written code or a code of conduct that you can utilize to ensure that your partners are acting in accordance with what the written agreement says. And then if you do need to go to court, which should always be the last option, that you now have a written document that you could show to a judge, that you can show to an arbitrator, that you can share with the mediator, that's going to be able to show what it was you were supposed to do, what it was your business partners were supposed to be doing, what they didn't do, and why they violated the agreement. And for a number of other reasons, you'll see the benefits of why it makes sense to have these types of documents written out. So what should go into an operating agreement? First and foremost, I'm going to run through a list of different things that you're going to want to see in your operating agreements when you're preparing them, or if you're receiving them from counsel, or if your counsel's receiving it from another attorney. These are the things you're going to want to make sure that's in there. And you can ask your attorney to confirm that they are. So number one, ownership structure. You always want to make sure that the equity ownership of the company is clearly delineated in the agreement. So either if you're an LLC and you're a member, what's your equity? Do you have a third of a percentage? Is it 10%? Is it 50%, 75%? That will have enormous ramifications because technically voting rights should be 51% or more for you to be able to make decisions as a majority owner. Next becomes the management structure. So what is it that everybody in the company is supposed to be doing? In a corporation, you tend to see a CEO, you see a treasurer, you see various different officers and directors that are elected to the company to be able to operate and guide it. And in an LLC, those are the types of things you do want to consider. Are the members of the LLC going to manage the company? Which one? What are their roles and responsibilities going to be? Who's in charge of daily operations? Who's in charge of the financials? Who's going to be dealing with sales? Who's going to handle the marketing? Is it just member managed and internal, or are we planning on hiring the staff over time? These are some things to think about, but one of the big disputes we often see is one partner coming to us saying they have two other partners, but one of the partners simply is not carrying their weight, and that one partner is denying that it was ever their role or responsibility to do something. So it's always very important to write that out. Number three, capital contributions. What capital contributions are being made by the various members to the company? In the original operating agreement, it's always a very important and good idea to set forth the amount of contribution made, because a smart thing to do is if you have an investor that's invested in the company, often in the LLC structure, you're going to see a provision that will allow that member to first recover their contribution before distributions can be made to all the members. And especially if you're an investor, considering even if you're going to be a silent investor in a company, you're probably going to want to make sure that you get that contribution back before distributions start being given out to all of the owners. Number four, you'll want to consider what's the schedule for the distributions and allocations of profits and losses. With respect to distributions, how often will the members receive distributions? Is it on a quarterly basis? And how much of profits are we going to distribute? Is that subject to a quarterly vote? Is that decided by the managing member? All members are entitled to receive their equitable share of a distribution unless stated otherwise in an operating agreement. But these are things that you're going to want to see in writing, because you can always amend, change, and alter these items unless they're written in stone. Voting rights. Normally, the majority member is going to have a lot of power in an LLC or a corporation. However, if you want to shift voting rights to make them equal or change something, even if one member owns a majority, if you want to have equal voting rights, that's something you can write in to an operating agreement. So distributions may still be 60-40, for example, in favor of one member, but voting rights might be equal. These are things that you can work on and write out in an operating agreement. Transfers of ownership. This is a big one. What do we want to consider? What if I'm a member of a company with you and I'd like to sell my shares? If I want to sell them to you, how are we going to decide what the value is? Well, maybe we have a provision in there requiring a valuation of the company at the election of either member. Maybe we also include a provision in there to state that the company is going to pay for that valuation. Regardless, this is something you want to consider. And then what happens, for example, if one of the members wants to sell their shares to a third party? Well, maybe what we can do is we can have a right of first refusal, where the selling member first has to present an offer for sale to the member that's not selling their interest, and the member that's not selling their interest gets the option to purchase the shares before they're potentially sold to a third party. Without this language in an agreement, everything goes up in the air. Deadlocks. In fact, I'm going to save deadlocks for a little bit later on. Indemnification is an important provision that we always want to consider. So what happens if, for example, one of the owners of the company does something, and it's not that it's so egregious, perhaps it's arguably negligent, but it was within the scope of their performance of their duties, and now the company's defending a lawsuit, and maybe that individual member is being sued as well. you can have indemnification language in the agreement that states that the individual who's being sued will have his or her legal fees covered by the company. These are things you're ultimately going to want to think about. Beyond that, you may want to have a provision concerning inappropriate conduct. So, for example, if one of the members does something that's considered to be inappropriate, improper, fraudulent, intentional, or even reckless, then indemnification wouldn't cover to them. And in fact, maybe you have a provision that talks about what happens when bad faith acts are taking place. Perhaps there's a way to eject that member from the company. And whether or not there needs to be a compensation of fair market value for their equity needs to be made, that's something to consider and to put into an agreement. Okay, so those are just this number of different examples, right, that I just rattled off to you concerning these operating agreements. Then we're really going to focus and get to the heart of the dispute resolution portions of an operating agreement. So when we consider what to look for, there are really three areas that I'm going to focus on. Number one is a deadlock provision, which we'll talk about in greater detail. Number two is a choice of law / forum selection clause. And then number three is going to be the issue of attorney's fees and how that should be governed in a document. And 1 second, I'm just going to turn off my Microsoft Teams as it's been quite active, and we like to avoid that while we're speaking. So just give me 1 second. Okay. So with respect to these provisions of the agreements, these are going to be the important ones, these clauses when it comes to dispute resolution. So number one, what is a deadlock provision? A deadlock provision is a provision in an operating agreement that sets the stage for what should happen when you have two members, but it could easily be applied when you have four or usually any even number. It's a provision that states what to do when the parties simply cannot make a decision. Now, if you don't have an operating agreement, what happens? You have two individuals that start feuding, things aren't going well. One starts taking one measure, the other partner starts retaliating, and before you know it, you're going down this path of he's doing this wrong, she's doing that wrong, things are getting worse. If there's staff and employees and a C-suite, everybody's recognizing there's this issue within the company and things aren't looking on the up and up. If you have a deadlock provision, you might be able to put this behind you relatively quickly. So what do I mean by deadlock provision? Well, there's a number of ways you can structure this. So one option for a deadlock provision would be to assign a third party the role and responsibility to make a decision when two partners or more partners in a company are deadlocked. So as an example, party A and party B are feuding because they believe that one party believes it's in the best interest of the company to purchase a particular asset. The other partner says, absolutely not, no way, we can't afford it, or we think it's going to detrimentally harm our business. And two partners have to be in agreement on an acquisition. So maybe there's a 50-50 vote, right? And now we're deadlocked. What should we do? One wants to move forward, the other doesn't. So one party can implement the deadlock clause, and they send a notice to the other partner. And now you have a third party in the operating agreement that the parties already concluded who that would be when they sign the document. So it could be an attorney, it could be a CPA, it could be a trusted advisor to the business. But ultimately, that third party that was appointed in the deadlock provision when the operating agreement was signed is going to make that final decision. So that's where the deadlock provision can come into play. And whatever that decision is going to govern. So you can imagine how much that can help a company when we have this one party this third party that now can render proper and final determinations, and the company then proceeds from there. Another example of a deadlock provision, it starts to get a little more complex. You can have many different layers, but would be an example of two partners that are entered into an agreement together. There's a deadlock provision where if the parties simply aren't getting along and there's absolutely no ability for the two sides to come to terms, one partner can send a letter initiating the deadlock provision stating that I am going to buy you out on fair market value. So we'll call them the acquiring partner. Now, the defending partner, so the other partner who didn't make that demand, now has the opportunity to either agree and to be bought out for fair market value, or that defending partner has the option pursuant to that deadlock clause to go back to the initiating partner and say, I'm going to buy you out for fair market value. So these deadlock provisions are interesting because when you set it up like this, there's always going to be a potential risk to each party, right? So if I initiate that clause and say, I want to buy you out, or if I'm party A and party A says, party B, I'm going to buy you out, I know that something's going to happen, right? Either I'm going to be able to buy out party B, but I also know party B might be able to come back to me and say, actually, party A, I'm buying you out. And at that point, the decision's final. So these are clever ways to and the reason that that type of provision, which may sound a little harsh, is sometimes utilized, it's really because we want to avoid a dissolution petition. And a dissolution petition is something that gets filed when the company is basically torn apart, the assets get sold at an auction because the partners simply cannot work together. So this allows for the company and business to continue with one partner getting the benefits of having their equity purchased at a fair market value, subject to an independent third-party valuation, or the partner that keeps the business gets to now carry on, and even though they'll be paying to buy equity, they will now be the 100% owner. And we've seen this structured in many ways where a buyout can be done in a staggered manner so that installment payments are made. Payments even come from certain levels of receivables in conjunction with the promissory note. There's all different types of interesting ways to piece these provisions together. But a deadlock provision is a great way to ensure that we don't reach a point where nothing's happening and we might just have to dissolve the whole business and lose everything. Moving on from there, choice of law and forum selection clauses. Now, this one's very interesting. We've seen a lot of different situations where forum selection clauses basically state where a matter is going to be litigated. So usually you'll pick the state. The choice of law portion will be the which laws will govern. So normally, let's say it's New York State. And then the forum selection will consider, number one, is this case going to court? Number two, is it going to go to arbitration? Or number three, is it going to go to mediation first and then arbitration? And a lot of these agreements are stylized in very different ways. So for example, you might see something that says, the parties hereby agree that they shall first enter into good faith negotiations to try to resolve any dispute. If, however, within X amount of days they cannot resolve a dispute, then mediation will ensue. And if mediation is not successful, then the parties will proceed to litigation in court or arbitration. Now, an interesting question comes up, and we do get this a lot. What's the better tact or the better path to go down? Would we rather be arbitrating or would we rather be litigating claims? We generally like to stylize, our agreement in a way where we first require the parties to mediate claims. If we're able to reach an outcome without going to court, great. Otherwise, we do usually recommend an arbitration clause in the agreements. And here's why. When you go into court, the benefit of court is that you're able to potentially appeal a decision that you're not pleased with. So one party sues another, there's litigation, perhaps we get to the point of trial, there might be motion practice, but any decision is appealable. So if we feel or there's a feeling that the court erred in their decision, there's a remedy to alter that. So having that opportunity is a benefit. The other benefit of litigation is you're not paying for the judge's fees. Of course, you're going to have to pay legal fees, but you don't have to worry about paying the judge. You're not paying the court system except for filing fees. So there's a cost-effective potential component to it. The negatives are that, unfortunately, litigation, especially in state court, can take really a longer period of time than arbitration. It could be 1 to 3 years. Federal court's a little better. But then you're also dealing with the public realm because when complaints are filed, they're filed in the public forum. Now, if you file in federal court, interestingly enough, usually in Google searches, that's going to come up pretty quickly. If you're filing in state court, not as much, but it's still a public filing and accessible to the public. So in these types of instances, what winds up happening is there's a PR component to litigation, especially when you have a partnership dispute. And when you have a partnership dispute, remember, anytime that's publicly filed, your company's likely going to suffer. Customers are going to see this, patients are going to see it, clients are going to see what's happening, your employees, your staff, everybody's going to be put on notice, your vendors, and that's a potential issue. And if everybody sees everything that's going on in the company, it's likely something that you want to avoid. If you go to arbitration, the detriments are arbitration is more expensive most of the time. You wind up paying the arbitrator's fees, which can add up. But the benefit is that it's kept confidential. Arbitration is private. And you often can reach a decision or get to a hearing within 6 to 8 months. Now, a decision in arbitration cannot really be appealed. It can only be appealed if you argue that the arbitrator was acting in an arbitrary and capricious manner when making a decision, and that's a very high standard. So generally speaking, the decision made by the arbitrator is going to be final. So we often recommend that you utilize an arbitration clause, especially if you're worried about a potential PR downfall that could arise from a public filing. However, you might have some various considerations in your business where you say, you know what, that's not what I want. I prefer to proceed via the court system. So moving on from there. So now I've provided you with a summary of what an operating document is, what it does for the company. I've gone through a number of different and various provisions that you should have in your operating agreements. And I've discussed issues such as a deadlock clause and such as a choice of law forum in an operating agreement. One thing I do want to add is attorney's fees. It's something that you can put into an operating agreement. In the U.S. system, and we get this question asked to us a lot, typically speaking in the U.S. system, unless it's provided by a statute or unless a contract calls for it, the winning party in a litigation is not able to collect their attorney's fees. And it's true if the conduct alleged is so egregious and punitive in nature that attorney's fees may be warranted, it could happen. But 9 times out of 10, unless it's in a statute or in a contract, it's not going to. So what we do recommend is that you put in your agreement a provision that states that the successful party in litigating an action is entitled to recover their attorney's fees. And there may be instances where that doesn't make sense to do, but it's often something to at least consider. All right, so that will conclude part 1 of our analysis here of what do we want in an operating document that's governing the relationship between business owners together. Okay? Going to take another water break. So now let's move on to phase 2. Phase 2 is going to consider what to do when we actually have a dispute. Now, disputes can range in terms of the scope, in terms of what's being alleged, in terms of the gravity of what's taking place. So one type of dispute may be that my business partner isn't performing the services that they're supposed to, but it sort of ends there. I have a problem. We have an operating agreement. The manager is supposed to be doing X, Y, Z. They're not doing it. The business is not getting harmed that badly, but this is a problem. And if it doesn't ameliorate, then it's going to grow and grow and grow over time. Disputes can also get a lot worse. Hopefully you have confidentiality provisions in your operating agreements. But perhaps there's a scenario where one of the partners is taking the customers away from the business. They started a competing business in violation of the terms of the operating agreement that has a non-compete clause. So now they're taking the customers away, or they're taking the trade secrets, or perhaps they're even stealing the intellectual property that belongs to the company and using it on their own and getting customers that way, causing a bunch of confusion, resulting in monetary damages to the company, and the aggrieved partner needs to do something. Well, what do we do? Number one, you can always try and talk to your partner. Review your operating agreement would be number one. Hopefully you have one. And if you do, look through it to see what options you have. You'll also want to consider, what do I want at the end of the day? Do I want to try and get rid of this partner? And if so, do I have a clause to eject them? Or do I have a mandatory buyout provision that I can implement? Or is it that I want to get them to continue to perform? That's a valid consideration. So moving on, you then are faced with an option. You can work on this on your own and confront your partner. You can show your partner the operating agreement, reflect the provisions that are in your favor, and see if they'll agree to some sort of resolution. If that works, great. If you don't have an operating agreement, you'll want to read the New York Limited Liability Company Law or the Business Corporation Law, because you still have statutory rights. And what are some of those rights? As an example, even if your operating agreement doesn't allude to it, you can inspect the books and records of your business. So what does that mean? Well, you have an unfettered right to look at various financial documents of your company, because if you're an owner, you have the right to know what's going on. So what does that actually mean? Well, I'm entitled to see tax returns. I'm entitled to look at profit and loss statements, bank statements, what's taking place with the balance sheet, what's happening in terms of the equity in the company, what are the vendor agreements that we've entered into, where are the monies of this company going. So ultimately, you have a right to be able to inspect on reasonable time and reasonable notice financial documents and other documents of the company. Now, if your efforts on your own are not leading anywhere, then your next steps are going to change. And if you work with a law firm such as ours, the options are going to be, number one, preparing a demand letter, so setting forth an out-of-court demand to the other side, demanding that they either cease doing something or take an affirmative action to put them back aligned with either your operating document or just general business practices on the up and up. Step number two would actually be filing a claim. And that would be in court or in arbitration, or if necessary, mediating before arbitration. So backing up now, working with a law firm, if you're going to send a demand letter, what would the law firm do? Well, the first thing we would do is we would want to inspect the documents that support the allegations you're making. So we have proof, for example, that my business partner is competing with the business. They started a separate entity, they owning it with other people. And what they're doing is they're utilizing our trade secreted data to mimic what it is we're doing here, and they're profiteering off of this. Well, what we would then do is perform an analysis of the operating agreement, perform an analysis of the relevant laws, perform an analysis of the documentation showing proof of what you're stating, and then we do the following. We unpack all of these facts in a letter that's sent confidentially for settlement purposes only. In that letter, we are going to set forth the factual allegations. We'll use exhibits to justify or support whatever exhibits those are that support the factual allegations. We'll then set forth the numerous violations of the clauses of the operating agreements or of the LLC law, and often it can be both. So we're demanding access to records because we've been locked out of the company bank account. And we're also demanding that you cease, desist, and refrain from violations of our intellectual property and using our trademark when it's owned by the company and you have no right to do so on your own. Then we often set forth the various claims that we have against the opposing party. So, for example, members of an LLC owe a fiduciary duty to one another. So we could allege that their conduct arises to a breach of their fiduciary duties, a breach of the operating agreement, potentially fraud. They are also unjustly enriching themselves, and perhaps they're taking business opportunities away from the company and bringing them elsewhere, and that's a claim for a usurpation of corporate opportunities. So we unpack the facts, we set forth the various violations of the company documents and or the statutory law, and then we set forth the claims we have in court. Then we like to shift and discuss a possible resolution. So we make clear that at this juncture, based upon everything that we've seen and what we see, that the breaches that we're aware of, we believe that we have claims for XYZ, which could result in extensive damages along with XYZ. And then we like to propose a potential resolution. Sometimes we'll say we'll demand a full accounting of the books, records, profit and loss statements, bank accounts, tax returns, et cetera, of the company. Or in the alternative, if your client is willing to pay, let's say, a lump sum of $2.5 million, then we will agree to walk away from claims. And absent acquiescence to either the full auditing and accounting or the payment within X amount of days, we intend to pursue this action in court. The benefit of doing it like this is that you get to sort of create the narrative early on. The demand is still confidential. So at this point in time, it's almost like, forgive the lack of a better analogy, but we're holding a loaded gun to the opposing side, because especially if there's no arbitration provision, if this goes public, it's going to be a major problem for not only the person alleging the claims, but more so for the person that's being alleged, that we're alleging all the wrongdoing against. And it's a possibility of resolving the claim without having to spend a significant amount in litigation. So demand letters, the benefit, once again, is that they're more cost effective than litigation. The detriment is that it's not guaranteed to bring any result. So a bad faith actor, now there's two types of bad faith actors, I should say. One type of bad faith actor likely sees a demand letter and they're worried, they're nervous, right? They realize I've committed violations of the law. This is really bad. We like to set forth our demands with very strong language, very fervent language. And when people receive these, they get worried. So they may retain separate counsel that then contacts our firm and we work on a resolution together. Or see if we can get to the point that we actually can get an outcome that's aligned with our client's interests. The alternative bad faith actor has been through this many times before. So they're often the people we caution you not to get into business with in the first place. And if you do, you're going to want an ironclad operating agreement to govern the business. But in these instances, they may still violate them anyway. And in those cases, sending a demand letter may be fruitless. So often we'll work with the client to get a sense of their MO in terms of what they're looking for, what do they really want, but then also to consider, would it make sense to even send the demand letter, or does it make sense to go to court? So if we go the demand letter route and we're able to obtain an outcome, then everybody's happy. Our client has now achieved an outcome. You've either taken over control of the business, you've managed to sell your share in the business, you've ejected this partner, or you've done something to allow you to move on in a way that gives you peace of mind and carry on. Or maybe you've gotten monetary damages because monies were submitted to a third party or removed from the bank account, but we were able to recover them. If a demand letter is not successful, or if we don't feel that it's viable in the first place, then we go and look through the lens of filing an action. Now, if you have an arbitration clause, you're filing a statement of claim in arbitration. Or if you don't, then you're filing a complaint in court. Now, there's two ways to do this when you go to court. And we're going to talk through the lens of filing a claim in court. There's my little coffee and water break. And maybe we should be having a coffee and water intermission for everybody that's here. So now we've moved on to the point that we need to file a complaint. When we file a complaint, what we do is, it's very similar in ways to the demand letter, but it's a lot more formalized. So we deal with the issue of jurisdiction, we deal with the issue of where the proper venue needs to be, and then we set forth all the facts in line item form as to what's taken place, when it took place, and then we bring us up to the present date about all the wrongdoing that's actually occurred. Any exhibits that are corroborating or support the factual assertions, we make sure to attach them to the complaint, unless for certain strategic reasons it doesn't make sense, or if there's a confidentiality issue we need to be mindful of, it may be redacted or submitted for in-camera review. We then set forth all the violations of the operating documents and/or the business corporation law, or the LLC law, and then we set forth our causes of action. The causes of action are the claims that we reference in the demand letter. So it's the factual background, the violations of the operating documents and/or the statutory relevant statutes, and then we set forth the causes of action. Breaches of fiduciary duties, unjust enrichment, breach of contract, usurpation of corporate opportunity, violations of the Lanham Act, if there's been any trademark infringement, violations of the US copyright laws. We often make a demand for an accounting. And if we think that the company is on the brink of such chaos, we may want to suggest that a receiver, a temporary receiver, be appointed to oversee the actual conduct of the business to ensure that the business doesn't implode. Now, what does that do? Once you file the complaint, it needs to be served. It's served on the opposing party, depending on the way they're served. The defendants will have either, and by the way, if you're alleging claims of fraud, then which need to be separate from claims for breach of contract, you may also be suing the individual actors in addition to the company, or if it's a third-party company, you're suing as well. So I should say you're often suing your business partner, but if they've opened up separate entities, you might be suing those as well. Now, depending on the severity of the action, a complaint alone may be enough. So you file the complaint, you send it out for service. Depending on how the defendants are served, they have 20 or 30 days to respond. Now you're in litigation. Our litigation MO is to always fight very hard to ensure that we're very professional, we're very tough, we're ultimately seeking outcomes that our clients want. And at the same time, though, while we aggressively pursue an action, we're always keeping the line of communication open up on the side. And that's kind of the Sun Tzu art of war mentality of fighting your battles hard, but keeping the line of communication open. Just because we know that litigation can get expensive. And at the end of the day, if one party is looking to resolve sooner than later, and that's aligned with our client's ultimate interest of what they're looking to obtain, then it probably makes sense to keep that dialogue window open. But then we hit, and I should say that we do that often, and we simply file the summons and complaint, and the case carries onwards, and we're always keeping in mind the possibility of resolving, and what we do is we need to ensure the case proceeds forward. Now, other times we're dealing with a situation that is so egregious that filing a complaint alone simply isn't enough. And we touched upon this in the last slide when we dealt with TROs and preliminary injunctions. So I'm going to give you an example of when you might need a temporary restraining order against another party or an injunction. I'm going to use an actual case from our firm as an example. I'm going to change the practice areas, the names, everything, so that there is no ability to reveal any of the specifics. But ultimately, what took place was as follows. You have two members that own a business. There's a number of different satellite businesses that relate back to the ultimate owner of the original company. And one member is a 51% member. The other member is a 49% owner. The 49% owner is operating the satellite office that's located in Westchester. And in the Westchester office, there's a number of different customers that are constantly coming in. A lot of sales get made, a voluminous amount of sales daily. And there is technology and computer software that's utilized daily in order to ensure that those sales can be made. And these sales are very time sensitive. They're very important. And any loss in the ability to move matters along could actually result in very severe damages. So the majority member of the company and the minority member who's running the Westchester office get into a feud. The dispute only worsens over time. The relationship gets to the point that it's breaking down and breaking down. The majority member then decides to do a few things that weren't prudent. Number one, the majority member locks the minority member out of the company bank account. Says, you can't see this. I'm not going to give you access anymore. Then after that, the minority member walks into the Westchester office and all of that software technology gets shut down. Within 24 hours, the internet at the location is then shut down. Then the minority member comes to hear that all of the customers that were going to this Westchester office were being called by the New York City office where the majority member had a company. And they're saying that the Westchester office is permanently closed, but come to our new facility, which is located downtown in the financial district. The original main company office was Midtown. The minority owner gets word and says immediately we need to file suit. And that's exactly what we did. Claims for fraud, unjust enrichment, fiduciary breaches, usurpation, corporate, everything you can name of gets filed. But here's the thing. That wasn't enough to protect this minority member, because the reality is the majority member utilized a new entity that he had opened to open up the downtown office and divert all of the customers to go somewhere else. So this minority member was stuck in a position where if we don't get an order to show cause or some ability to, number one, perform operations, and number two, get the majority member's office from stopping to call all the customers telling them to go to this downtown office, there was going to be a complete loss of reputation, the ability to work, the ability to earn. It was going to be awful. So we had to run into court and file what's called an order to show cause for emergency relief. And that emergency relief was a temporary restraining order to, number one, enjoin this majority member from calling any further customers to say that the office was closed. Number two, the order also needed to obtain language that said that the technology had to be restored. And number three, the majority member was also required to restore the internet at the location. Now, we were able to do that within 24 to 48 hours. A temporary restraining order is something that you get when you file all these documents, you run into court, and you get that TRO. Within then, usually the judge has the parties come back within 2 to 3 weeks, where the judge gets an opportunity to review the full briefs of each party and decide whether or not this TRO is going to extend throughout the duration of the litigation. If the answer is yes, then it becomes a preliminary injunction. If the answer is no, then it gets dropped. Ultimately, in that case, we were able to secure the preliminary injunction predominantly because absent that immediate emergency relief, our client was going to have no rights, so that if we got a judgment a year and a half, 2 years later, which this one wound up in a separate forum, and we did reach a positive resolution and went to arbitration. But ultimately, the idea was that if we were not able to secure interim relief, our client would have been out of luck. Customers would have all been gone, would have had no ability to collect revenue. The business would have been destroyed. So that issue of irreparable harm, whether or not I need to seek additional relief immediately, all comes down to if you believe that if you don't seek that relief, your company is going to be rendered worthless. Now, if it's not, and you believe that the parties are continuing, but we need to litigate because they're doing bad things, but my company's not going to be completely fleeced and depleted, then maybe you don't need to get a TRO and a preliminary injunction. But if you do believe that's going to happen, then you likely do. So we're now at the point where we've discussed operating documents, the benefits of having them. We've discussed various clauses you'd like to see in those operating documents. We've even discussed dispute resolution clauses that you'd want to see in operating documents. We went through the deadlock provisions. We went through the choice of law provisions. We discussed the shifting of attorney's fees in favor of one party over another. So that way the winning party can actually not only obtain monetary damages, but attorney's fees. And then we talked about what your options are if you do proceed to try and enforce your rights. Number one, you can send a demand letter setting forth the facts of what's taken place. You can set forth the various violations of the operating documents or statutory laws. Then you set forth the claims that you believe that you can satisfy by alleging against the opposing party. And then you can also give a date certain where you propose a resolution and demand that they adhere to those terms by a date certain. Otherwise, you file for litigation. We also discussed going right into court or to arbitration by filing a complaint in court or a statement of claim via arbitration. And then we discussed that additional tier where if you believe you have an emergency situation such that if you don't stop this bad faith actor now, your company is ultimately going to be destroyed, then you can file, in addition to your complaint or your statement of claim in arbitration, a measure. You can file an order to show cause for emergency relief to get a temporary restraining order, and then ultimately a preliminary injunction. So that ultimately concludes the basics of how to stop your business partner from stealing from you. I hope this was valuable. I hope that the information shared and gleaned was beneficial for your efforts, either as an attorney in terms of your practice of law, whether you're in the business field or in another field, or as somebody in another business, as a business owner who potentially has a dispute or doesn't have one, but wants to make sure that one doesn't come up in the future. So at this point in time, what I think we'll do is we're going to end. And if anybody's sending messages, by the way, I apologize because we still have not figured out how to see the messages in chat. In fact, I do see a couple of questions here. Okay, let's see. Okay, do you recommend hiring a private investigator to do a thorough background check into individuals you're considering doing business with? I would say it really depends. It would depend on the severity of what it is you're doing, and it would really depend on how well you know the individual. Always check, and unfortunately, I can't see who's asking the questions, but my concern would be that you need to make sure you're adhering to state laws. So if you're in a state other than New York, I would make sure that you check local laws for the requirements on that. But ultimately, if you believe that there's a significant issue with your partner, that might be a feasible thing that you're going to want to do. Can you ask the court to keep it private? So ultimately, when you're filing a business litigation claim, it's very hard to get documents sealed. You'll essentially see that in a criminal matter. But oftentimes in a civil dispute, unless there's something that's so severe and extreme and sensitive in nature, where there might be significant physical harm or something to that level, generally you're not going to see a sealed complaint when it comes to civil litigation. Now you might see redacted documents. So for example, there's private information that will come up with redactions when they're filed, or you might ask a judge to inspect in camera certain discovery or documentation. But ultimately, sealed matters are very rare in civil cases. Somebody else said, so interesting and educational. Thanks, Ross. I will be referring to this in the future. Great. I'm so happy to hear that. Again, I'm sorry I can't see who you are, but that certainly makes me happy. And I'm glad that this is valuable because I do know it's important, certainly for business owners and others that are looking to ensure that they can either guide people properly or ensure that they themselves are protected. Hey, Kyle, this was really interesting and informative. Thank you, Ross. You're very welcome. Well, again, everybody, thank you so much for attending. If you have any other questions, you can email us. You can email me directly at ross@pitcofflawgroup.com. Shoot me a note on LinkedIn or Facebook, any social platform you're watching this on. You can send us an email, info@pitcofflawgroup.com or ross@pitcofflawgroup. And if you have a topic you're interested in hearing about for the next LinkedIn Live, which we're endeavoring to do once a month, shoot us a note. We're really curious to hear what are your concerns or questions you would have, and we're happy to deep dive into something and kind of unpack it in a way that's valuable. And David, thank you for the information with us being a new partnership. Awesome. Glad it was helpful. If anything else comes up, just feel free to reach out. And thank you very much.